Hello, my name is Emmanuel Elau. I'm an assistant lecturer at the Faculty of Law. I am very delighted to have you today in this class, well aware that this is our inaugural class as a faculty and specifically to constitutional law. So you're part of history today as you join this class. The course unit that I'm going to be taking you through is called, or is named, Constitutional Law. And as you're aware, constitutional law, the name is derived from the study of constitutionalism or the Constitution. If you go to different parts of the world today, many countries have written constitutions. Though, of course, some of the advanced countries as well, for example, the United Kingdom, they do not have a written constitution. They have pieces of legislation here and there. Now, by the time we're studying constitutional law, I believe that you'll have been introduced already to constitutional history. You'll have also been introduced to law, Introduction to Law, which is also a course unit within the Faculty of Law. So with that background, at least you have an idea of what the law is and what the sources of law are in Uganda. One of the major sources of law in Uganda today, of course, is the Constitution of Uganda of 1995, alongside other sources such as customs, common law, principles of equity, etc. The Constitution is very, very important to us as a country because it emphasizes democracy. And you cannot rule a country easily where there is no democracy, where there is no free will of the people that they express after every now and then through elections, the ballot box. So the ballot box is very important, and so that's what makes the study of constitutionalism or the Constitution very, very important, because it enables you in various ways to understand your rights, to understand where we as a country have come from. The Constitution of Uganda of 1995 is not the first constitution that we have had. We have had previous constitutions, which I believe you have interfaced with as you're studying constitutional history. For example, the 1967 Pigeonhole Constitution. We have the abolition of the Constitution in 1971 by Amin, and then the different legal notices that have brought the different governments into power in the past. But the advent of the NRM rule in Uganda meant that the president at the time was very much interested in constitutionalism, and so the Constituent Assembly was elected. And among others, the role of that assembly was to make for us a constitution. And so it is very, very important for us to study the Constitution so that we understand our past and where we're going. So that when you're criticizing any leader in Uganda today or in any part of the world, at least you know where we have come from. So the different parts that we're going to be studying, but before I get to that, as we're studying this course unit, you must ensure that you read the different cases which will be provided to you in the reading list. The reading list is basically the brief of the different parts that we're going to be studying. It has the different reading materials that you must refer to. It has the different cases that you must refer to. I believe by now they should have told you that to study law, it is very unavoidable to read, especially to read cases, decided cases at that, because they form part of our laws, because the cases help to interpret the law. Okay, so make sure that you read the cases that are provided for in the reading list. Now, the different parts that we're going to be studying include the nature of the Constitution as a beginning point. Like I've already made references to the Constitution. Article 2 of the Constitution of Uganda is very, very important, alongside other articles that you'll see in the reading list, because it says that Article 1 says that power belongs to the people. Okay? Then Article 2 of the Constitution emphasizes the supremacy of the Constitution. And it also goes as far as saying that any other law which is inconsistent with the Constitution is null and void to the extent of that inconsistency. And so you might want to interest yourself in Article 1, Article 2, Article 3. In the past we have had unconstitutional changes of government, but the current Constitution of Uganda outlaws unconstitutional change of power in the country, though of course it has never been tested to date. So I invite you to read the different articles and the reading materials in that particular part. The other very important part that we're going to be studying is the basic structure doctrine. Now the basic structure, this theory, though of course it is contested in different parts of the world, the most recent being in Kenya, the fact of whether the constitution can be amended. Can the constitution be amended or not? Okay? This basic structure doctrine was somehow discussed in Uganda as well by the Ugandan courts in the case of Malema Birezi, when they were challenging the amendment of the constitution to remove the age limit that enabled President Museveni to contest in the 2021 elections. So, can the constitution be amended or not? Okay, we'll be looking at the different interpretations from India, from Kenya, and also from Uganda. Importantly, the other general principles that we're going to be studying includes the doctrine of the separation of powers. Okay, separation of powers is very, very important in every country. Separation of powers. Now, every country at least has 3 different arms of government, okay? Or at least most countries. That is the executive, then you have the legislature, and then you have the judiciary. Now, as you can see in terms of hierarchy, the executive sits at the top of this hierarchy, okay? That's where the president sits with the ministers. Whenever a government is coming into power, they campaign on certain platforms. They will tell you they're going to amend certain laws, they're going to bring certain laws, taxation, human rights, and issues like that, okay? When they win power, they then go to the parliament, okay? The legislature, to put their campaign, whatever they gave to you during campaigns, their policies or proposed laws, they take it to parliament, which discusses it and passes it into law. And then if there is any need for interpretation, in case some people are dissatisfied with the law, then they can approach the courts of law for interpretation. And that's why you've had Malema Birezi playing a very critical role in coming up with the interpretation of various parts of the law. Now, the other part that we're going to be discussing is the question of citizenship. The question of citizenship. So we're going to be defining and interesting ourselves in the meaning of citizenship, okay? What are the various modes of acquiring citizenship in Uganda, okay? What are the rights and duties of citizens in Uganda? What about other classes of citizens? Now, you'll realize that there are different modes of acquiring citizenship, okay, in any given country. One, it could be by birth. It could be by marriage, okay? It could be, through staying in a country for a well-defined period of time. That as well could give rise to citizenship. Then what are the rights, okay, and duties of citizens? Being a citizen of a country means that you have rights. It also means that you have duties, okay? You have different rights provided for under Chapter 4 of the Constitution. For example, a right to life, a right to work, a right to found a family, among others. But alongside that, you also have duties. And it would appear that one of the most important duties of a citizen is among others to vote, to pay taxes, because government gets its revenue through taxation of its citizens. So we'll be understanding all those parts as we go along. The other very important part that we're going to be studying is the different branches of government. We have the executive and the cabinet. We have the parliament. We have the judiciary. And then there's also the discussion around judicial independence. Of course, earlier on, in the earlier slide, we talked about the separation of powers, okay? Separation of powers. But now here we're talking about the different branches of government, which of course is closely related. Now, the executive, like I said earlier, is composed of the president and his cabinet of ministers, okay? For which he has the powers to hire and fire at will. The parliament is elected, by the people. And then the judiciary, in the context of Uganda, the president appoints the judicial officers, especially the higher bench from the higher court, after the Judicial Service Commission has done the necessary interviews and the like. Now, much as the president appoints the judiciary or some of those judicial officers, the judiciary is independent. It cannot act under the direction of anybody in this country. It acts on its own. And so it remains to be seen as we study whether the judiciary in Uganda is purely independent or not. Of course, again, there are different schools of thought when it comes to the issue of judicial independence. Some schools will tell you that while the Constitution clearly provides for independence of the judiciary, other polls seem to suggest that in actual sense, there is no independence of the judiciary in this country. But that will leave to you to make up your own decisions or opinions when we study further. We also have another very important discussion to do with the general principles of constitutional interpretation vis-a-vis enforcement. The power to interpret the Constitution is vested with the Constitutional Court of Uganda. The Constitutional Court also, depending on the matter that they're handling, in some instances, if it is handling appeals, that court at that level, it's an appellate court, and therefore it is the Court of Appeal. But when it is dealing with matters of interpretation, it sits as the Constitutional Court. Under different rules of interpretation of the Constitution, that will be delving into once we start our discussions of the Constitution in detail. Also, it's important to talk about enforcement, because somebody must enforce the Constitution or the rule of law in this country. And that is basically vested with the government and its institutions, and also you and I as citizens of this country. So we'll be discussing that as well in detail. The last part that we'll be looking at is human rights. Human rights and civil freedoms and liberties, okay, which you can clearly see on your screen. Human rights and civil freedoms and liberties. So we'll be talking about the general principles regarding human rights. We'll be talking about the fundamental principles. We'll be talking about criminal justice and human rights, okay? Because we have the criminal justice system in this country, and then you have human rights. How do you balance, okay, the two? The Constitution, luckily, of course, provides for some of these issues already. For example, you have a right to personal liberty. If you are arrested and taken to a police station, you can only be kept there for up to 48 hours. Anything beyond that, you can apply for unconditional release, okay? But as to whether police in this country actually respects the 48 hours rule, again, remains a matter for debate. And the different cases that you're going to be referring to will throw more light and help you make up your own opinions. So the criminal justice system must be balanced with human rights. And again, human rights are provided for not just locally, but internationally, because we have the Universal Declaration of Human Rights, we have the ICCPR that provides for civil political rights, we have the African Charter on Human and People's Rights, we have the East African Community Treaty now that also provides for certain bits of human rights in conjunction with other international instruments to that effect. We'll also be talking about political rights and freedoms, whether we have the necessary space in this country to exercise political freedoms within the law. The right to life, which I had already alluded to earlier, you have a right to life as part of the human rights that are provided for in this country. However, in this country specifically, I must categorically state that the right to life is not absolute. It is qualified under certain circumstances because Uganda as a country still recognizes the death penalty as one of the harshest punishments that can be meted out to an individual for the most serious offenses. Women's rights and constitutionalism, okay, is also a very important debate. As you know, in the past, women were kept in the kitchen in this country. They were kept in the kitchen cooking food. They were kept in the gardens and within the home, and they had no access to education, to politics, and the like, name it, education. So the Constituent Assembly in 1995, when they enacted the Constitution, thought it wise to safeguard certain rights for women, including equality in workspace, education, politics, and the like. That's why you see the women MPs in every district. Today we have many more women graduating from the university, in fact, more than the boys. So in some instances, people are now talking of improving certain basic rights for the boy child as well, because they're being left behind somehow. And then lastly, the amendment of the Constitution. How can the Constitution be amended? Of course, the procedures are laid out there, okay, as to how it can be amended. But we'll be discussing this in the context of the basic structure doctrine, which also says that certain parts of the Constitution cannot be amended. So that will be all that we'll be studying in this course unit specifically. But like I emphasized earlier, I invite you to read all the cases, or at least try to read as many as you can, cases which are listed in the reading list. You should also consider looking at those different readings which are listed in the reading list. And then with that, you'll be a better student. You'll have a better understanding of constitutionalism in the context of Uganda and the wider world. I thank you so much for listening.